There is a gap in the docket book. If you were to walk into the Breathitt County Courthouse in Jackson, Kentucky, and ask the clerk, politely, with the right kind of patience, to pull the bound volume of civil and criminal proceedings for the year 1901, she would set it on the counter in front of you without ceremony. The cover is dark brown, the leather dried to the texture of old bark. The brass clasp that holds it shut has gone green at the edges. It smells the way all old courthouses smell, of dust and pine oil and something underneath those things, something older and harder to name, like the memory of argument itself. You would open it. You would flip through the pages, each one handwritten in the careful copperplate that county clerks were trained to produce in those days. The letters perfectly formed, the margins exact. January proceedings, motions filed, bonds posted, a dispute over a fence line on Troublesome Creek, a drunk and disorderly charge against a man named Combs, who appears to have been perpetually drunk and disorderly throughout the entire decade. The entries run through January 28th without interruption, each day's business recorded with the particular pride that small county clerks took in the completeness of their record keeping. And then there is nothing, not a blank page, not a torn page. The pages are gone, removed, with something sharp, a knife most likely, run along the inside of the binding with enough care to leave the spines intact, but enough force to take the leaves clean. If you run your finger along the gutter of the book at that point, you can feel the stubs, little paper tongues, each one perhaps a quarter-inch wide, the raw edges gone brown with a century of oxidation. Someone counted them once. There are enough stubs to account for approximately 40 pages of double-sided entries. Given the average length of docket notations in that period, 40 pages could contain 5 weeks of proceedings. 5 weeks. February and the first days of March, 1901. When the entries resume on March 3rd, there is no acknowledgement of the gap. The clerk, a different hand you notice, slightly looser in the letter forms, someone who never quite mastered the loop on his capital G, simply picks up where whoever came before left off. A property survey dispute. An appeal. The drunk and disorderly Mr. Combs again, evidently undeterred by whatever had happened in the interim. There is one surviving reference to what those 5 weeks contained. In the State Archives in Frankfurt, in a folder of miscellaneous gubernatorial correspondence from 1901, there is a single typed line. Typed, not handwritten, which is itself unusual for that period. That reads, "Case sealed by order of the governor, February 1901, Breathitt County." No case number, no name, no explanation of what the case concerned, what the governor's rationale was for sealing it, or under what authority such a sealing was ordered. Researchers have looked for the matching executive order. They have searched the governor's files, the attorney general's records, the state court administrator's papers. They have found nothing that corresponds to this entry. The order was apparently issued, and then the order itself was made to disappear. Someone went to extraordinary lengths to make a trial not exist. This is the story of that trial. Or rather, this is as close as we can come to that story, assembled from the fragments that survived the cutting. A reporter's notes found in a shoebox in Louisville in 1978, a handful of letters, the memory of 2 elderly residents of Breathitt County who spoke to a graduate student in the 1960s before anyone understood what they were remembering, and the testimony of the gap itself, because gaps, it turns out, are a kind of evidence. They have shapes, they have edges, and if you look at them carefully enough, the shape of what was removed begins to tell you something about why it had to go. To understand what happened in that courthouse in February of 1901, you have to understand what Breathitt County was. You have to understand Bloody Breathitt. And to understand Bloody Breathitt, you have to understand that the name was not a metaphor. The county sits in the heart of eastern Kentucky, tucked into the folds of the Cumberland Plateau, where the ridges run in long parallel seams like the fingers of a closed fist. The land is steep and heavily timbered, the creeks fast and unpredictable, the hollows deep enough that sunlight only reaches the valley floor for a few hours each day in winter. The soil, where it was flat enough to farm, was thin and rocky. The timber was excellent. The coal beneath the ground was extraordinary, though in 1901 most of it had not yet been excavated, and most of the people who lived above it did not yet know what was there or what it would eventually mean for their lives, and their children's lives, and their grandchildren's lives. They knew the land. They knew the trees. They knew who their neighbors were, and who their neighbors' grandparents had been. And they knew which families had blood between them, and which families were bound by marriage, and which families were bound by both, which in Breathitt County was common. The feuds had been running for decades by 1901, not in the way that popular history tends to remember them, not simple hillbilly vendettas, two families shooting at each other over a pig or an insult, though there were certainly incidents that looked like that from the outside and were reported that way in the northern newspapers, whose correspondents tended to arrive in Breathitt County with their conclusions already written and their condescension already packed. The feuds were, at their core, political and economic. They were fights over who controlled the county government, who controlled the courts, who controlled the sheriff's office and the tax assessor's office, and, most critically, who controlled the land records. Because the land records in Breathitt County were not simply administrative documents. They were, in the most literal possible sense, the difference between having a farm and not having one, between feeding your children and watching them go hungry, between existing as an independent family in a place your grandfather had settled and being a tenant on ground you'd once owned outright. The dominant feud of that period is known to history as the Hargis-Callahan-Cockrell feud, which gives you some sense of its complexity even in the naming, because most feuds are named for two families, and this one required three to even begin to describe its participants. James Hargis was the county judge. He was also the postmaster, the primary owner of the general store, and the principal shareholder in several timber operations. He was a large man in every sense, physically imposing, politically connected, economically powerful, and entirely comfortable with the use of violence as a tool of governance. His faction controlled most of the official machinery of Breathitt County by 1901. His opponents included the Callahan family, led by the former circuit court clerk Edward Callahan, and various associated families and political allies who had been cut out of power during Hargis's rise and were not philosophical about their displacement. Between 1899 and 1903, the Hargis-Callahan-Cockrell feud would produce an estimated 14 murders. County Judge Hargis himself would eventually be convicted of ordering an assassination. His son, Beach Hargis, would shoot and kill a man on the courthouse steps. A circuit court judge named Cardwell would be shot while presiding over a session of court. The county would become, for several years, essentially ungovernable by any conventional standard. The state militia would be deployed. Newspapers, from Boston to San Francisco, would run features on Bloody Breathitt with a mixture of horror and the particular fascination that civilized people reserve for violence they can safely observe from a great distance. Into this landscape, try to place a legal system. Try to imagine what courts meant in a county where the judge might be the man ordering the violence, where the prosecutor might be taking direction from one of the feuding factions, where witnesses had excellent reasons to develop sudden failures of memory, where jurors went home each night to families whose safety depended on giving the right verdict, where the courthouse itself had been the site of armed confrontations. The law existed in Breathitt County in 1901, but it existed the way a river exists in drought. You could see the channel, you could trace where it should have run, but the water in it was not water anymore. It was something else. It was the feuds wearing the clothes of jurisprudence. And it was in this context that a man named Calvin Sizemore had, over the course of 16 years, made himself indispensable to everyone and beholden to no one, and had become, in the process, the most dangerous kind of criminal that any community can produce. The kind that the community cannot prosecute because the community needs him. Calvin Sizemore had come to the law the way many men came to it in that era and that place, through proximity and appetite rather than formal education. He had read enough to pass the bar examination, which in Kentucky in the 1880s was not an especially rigorous process, and he had established himself first as a local attorney handling property matters, and then, through a combination of political maneuvering and what his contemporaries described as an almost supernatural understanding of how power worked, as the county's primary arbiter of land title disputes. He had been a justice of the peace, then a magistrate, then had served 2 terms as a circuit judge before the political tides shifted against him and he returned to private practice. But the title judge clung to him the way titles do in small communities, an honorific that outlasted the office. And he was Judge Sizemore to everyone in Breathitt County, regardless of what position he technically held at any given moment. His power rested on a single, elegant insight. In a county at war with itself, the one man everyone needs is the man who can provide legal cover for what they've already done. The land title system in Breathitt County was a labyrinth that Calvin had spent years learning to navigate and, eventually, to construct. Eastern Kentucky land records were, in the best of circumstances, an administrative nightmare. The original land grants from the Commonwealth of Virginia predated Kentucky statehood. They had been resurveyed, divided, sold, inherited, disputed, and in some cases simply lost, so that by the late 19th century, the recorded chain of title for many parcels was a fiction that bore only approximate relationship to who had actually lived on and worked a piece of ground. Calvin understood this better than anyone. He understood which titles were solid and which were vulnerable. He understood which surveys contained errors, intentional or otherwise, that could be exploited. He understood the difference between legal possession and legal title, and how to weaponize that gap. When the feuds intensified and families began seizing each other's land, through violence, through intimidation, through the simple exercise of power, that attaches to the winning side in any armed conflict. Calvin Sizemore was there to make those seizures legal. He filed the papers. He entered the orders. He declared titles invalid on technical grounds and issued new titles to whoever had commissioned his services. He played both the Hargis faction and the Callahan faction, providing legal cover for land grabs on both sides, collecting fees from both, being trusted by neither and essential to both. He was not loyal to the feuds. He was loyal to his own accumulation. What he had not anticipated, or had chosen not to consider, was his wife. Parthnia Sizemore, née Collins, had married Calvin in 1883, when she was 18 years old. She was, by the accounts that survive, an educated woman. Educated by the standards of her time and place, which meant she had attended a subscription school for several years and had read widely from whatever books she could obtain, which in Breathitt County was not many, but which she had exhausted and reread. She had a facility with numbers that her father, a school teacher, had recognized and cultivated. She had, by her own later account, believed when she married Calvin that he was a man of law in the fullest sense, not merely someone who practiced its forms, but someone who was committed to its spirit. She had understood her mistake within the first 2 years of their marriage. She had spent the following 14 years keeping records of it. The ledger was a simple thing, physically, a standard commercial account book, the kind sold in any general store, with a mottled black and white cover and pages ruled in pale blue. She had kept it hidden in a compartment she'd cut into the base of her sewing basket, a hollowed-out space beneath the false bottom, packed around with basting thread and fabric scraps. The ledger documented, in Parthenia's precise and educated hand, every fraudulent transaction she had witnessed or could verify. Names, dates, parcel descriptions, the amounts Calvin had received, the people he had dispossessed. She had been keeping it since 1885. By January of 1901, it contained 16 years of entries. She had kept it, she would later testify, because she believed, had to believe, needed to believe in order to continue functioning, that there would come a day when the system would be capable of hearing it, a day when the law would be what it was supposed to be, rather than what it was. She had kept it because the act of keeping it was the only form of protest available to a woman in her position, and because the act of keeping it meant that what Calvin was doing was not, in fact, disappearing entirely. There was a record. Somewhere in the base of a sewing basket, there was a record. What broke her? Or rather, what broke the particular equilibrium she had maintained for 16 years, was not any single transaction among the hundreds Calvin had conducted. It was a family named Mullins. The Mullins family had farmed a tract of about 200 acres on a fork of the left Beaver Creek for 3 generations. They were not wealthy. They were not powerful. They had no faction, no political connection, no patron in either the Hargis camp or the Callahan camp. They were simply a family on a piece of land they had worked since before anyone currently living could remember, with a title that was, by the standards of Eastern Kentucky, as clean as titles got. They had stayed out of the feuds by the simple and effective method of having nothing that anyone particularly wanted, until the timber company wanted their ridge. A company operating out of Lexington had been acquiring timber rights throughout the eastern part of the county. Most of the families with valuable timber had sold, some willingly, some under various forms of pressure. The Mullins family had declined. Their refusal was not political. They simply did not want to sell, and they believed, with the confidence of people who had never needed to question their legal standing, that not wanting to sell was sufficient. Parthenia learned, in January of 1901, from a conversation she was not supposed to overhear, that Calvin had been engaged by the timber company to invalidate the Mullins title. He had found a survey error, or manufactured one, the distinction being largely theoretical, in an 1847 resurvey of the original grant. He was going to enter an order declaring the title defective and initiating forfeiture proceedings. The Mullins family would have perhaps 30 days to contest it, but contesting it would require legal representation, and every lawyer in Breathitt County who was capable of handling a land title case either worked for Calvin or worked for someone Calvin could pressure. The family would lose their land. They would be tenants, probably, on ground their great-grandfather had cleared. It was not the worst thing Calvin had done. It was not even close to the worst thing. But it was the thing that happened on a Tuesday morning in January while Parthenia was holding a cup of coffee that had gone cold in her hands. And it was the thing that made 16 years of careful, quiet, patient record-keeping suddenly feel like complicity. She had kept the ledger, believing there would come a day. She had just realized, with the clarity that sometimes arrives in the middle of ordinary moments, that she had been wrong. There was not going to be a day. The system was not going to fix itself. The law was not going to become what it was supposed to be. Not in Breathitt County. Not as long as Calvin was alive and operating. She went to her sewing basket. She removed the ledger. She sat with it on the kitchen table for a long time, reading through its entries, each one a small, precise, documented catastrophe. Then she went to Calvin's study, where his pistol was kept in the right-hand drawer of his desk. He was reading when she found him. He looked up. She shot him once, through the chest, with his own pistol. He died within a few minutes. She sat down in the chair across from him and waited. When the deputy arrived, drawn by a neighbor who had heard the shot, he found Parthnia Sizemore seated in the study, with the pistol on the desk in front of her, and her husband dead in his chair across from her, and the ledger open on her lap. She looked up at the deputy, a young man named Tackett, who had been in the job for less than a year and was entirely unprepared for what he was looking at, and she said, with the composure of someone who has made a decision and is at peace with it, "I killed him. Now let me tell you why." Deputy Tackett did not, in fact, want to hear why. He wanted to get Parthenia Sizemore to the jail as quickly and quietly as possible, which he did, and he wanted to report to his superiors, which he also did. What he did not do, and what would later prove to be either an oversight or an act of small, unconscious mercy, was take the ledger. Whether this was because he didn't understand what it was, or because he was carrying a woman and a weapon and couldn't manage another armful, or because some part of him recognized that the ledger was not simply evidence, but something more complicated than evidence. We don't know. He left it on the chair where she had been sitting. By the time anyone thought to go back for it, Parthenia had told her lawyer about it, and the lawyer had taken possession of it, and the chain of custody had become, legally speaking, interesting. The prosecutor assigned to the case was Hayden Hargis. Not James Hargis, the county judge and patriarch of the dominant feuding family, but his nephew, a man in his late 30s who had been educated at the University of Kentucky, and who was, by the accounts that survive, genuinely competent in ways that his uncle was not. He was also genuinely ambitious, and the Sizemore case looked on its surface like the kind of case that ambitious prosecutors love. Clear facts, cooperative defendant, no complications. A woman had shot her husband. She had admitted it. The case should have been concluded in a week. What complicated it was Virgil Stanton. Stanton had come to Breathitt County from Lexington, which in itself made him an object of suspicion in a community that distrusted outsiders on principle. He was 29 years old, which made him an object of skepticism, even among those disposed to trust him. He had been practicing law for 4 years, primarily in commercial matters, and had no particular experience with criminal defense. He had come to Breathitt County because Parthnia Sizemore's sister lived in Lexington and had engaged him on behalf of her family. And he had come because he needed the work, and because, at 29, he had not yet fully internalized the professional wisdom that certain cases are career-ending, regardless of outcome. He arrived in Jackson, the county seat, on a cold morning in late January, collected the few personal effects Parthenia had been allowed to keep in her cell, and sat down with her for the first time in the small room adjacent to the jail, where attorneys met with clients. He expected to find a frightened woman. He found instead someone who reminded him, disconcertingly, of the best professors he had encountered at law school. Precise, organized, unhurried, and apparently more concerned with the accuracy of his understanding than with her own situation. She told him about the ledger in the same way she had presumably kept it, methodically, completely, without editorial comment. She explained what it contained, how long she had maintained it, where it had been kept, how she had gathered the information in it. She explained the Mullins transaction that had been the immediate catalyst for her action. She explained what she believed the ledger documented about the systematic corruption of land title proceedings in Breathitt County over a period of 16 years. Virgil listened. He was a good enough lawyer to know when he was hearing something important, and this was important in ways that he could feel but not yet fully articulate. He asked for the ledger. He spent 2 days reading it. On the 3rd day, he went back to see Parthenia and told her that he had an idea about her defense. The conventional defense, he explained, would be temporary insanity or extreme emotional disturbance. A husband who had mistreated her, a moment of crisis, the jury's natural sympathy for a woman in extremis. It might work. It probably would work, given the right jury and the right presentation. But it would require Parthenia to play a role she didn't seem interested in playing. The helpless, suffering wife who lost her reason in a terrible moment. And it would leave Calvin Sizemore's ledger unread, its contents sealed with the case, the Mullins family still losing their land, and everything that had produced the moment in the study continuing exactly as before. What if, Virgil proposed, they used the trial differently? What if the defense was not that Parthenia had been temporarily insane, but that she had been entirely rational? What if the argument was that she had killed Calvin Sizemore because he was in the act of committing crimes so entrenched, so thoroughly protected by the corruption of the very institutions that should have stopped him, that there was no legal remedy available, that the legal system had been so comprehensively captured by the criminal enterprise she was trying to stop that killing. The criminal was, in a terrible and limited sense, the only available act of justice. It was not a standard defense. It was barely a defense at all in the conventional sense. What it was, Virgil told her, was a platform. If they entered the ledger into evidence, if they put its contents before the court, named the names, put the numbers on the record, then, regardless of what happened to Parthenia, the corruption would be exposed. It would be in the record. Newspapers would be there. The Louisville Courier-Journal had already sent a correspondent. Parthenia was quiet for a moment. Then she asked, "Would it help the Mullins family?" Virgil said he thought it might. She said, "Then that's what we'll do." What Virgil had not fully calculated, what perhaps no one could have fully calculated because the implications only became visible once the trial began, was the way in which entering the ledger into evidence would not merely expose Calvin Sizemore's crimes, but would expose every faction, every family, every powerful interest in Breathitt County that had used those crimes for its own benefit. Calvin had worked for everyone. His ledger implicated everyone. The Hargis faction, which controlled the prosecution through Hayden Hargis, the Callahan faction, which had its own relationship with Calvin's services, the timber company, the county surveyor, the clerk of courts, the bank. Virtually every significant power center in Breathitt County had, at some point, been a client of Calvin Sizemore's particular expertise, and Parthenia Sizemore had written all of it down. When Virgil began to understand this, when he sat with the ledger long enough to map its full reach, he spent a night that he would later describe in a letter to his law school professor as the most frightening of his life, not because of any direct threat, but because of the slowly clarifying understanding of what he was proposing to do. He was proposing to walk into a courthouse in the most violent county in Kentucky, in the middle of an active feud that had already produced multiple murders, and put into public evidence the documentary proof that every significant faction in that feud had been using the legal system as a criminal enterprise. He could not have known, in those nights of calculation, exactly how right he was to be afraid. But he had enough information to be afraid, and he went forward anyway, which is either courage or recklessness, and is usually, in retrospect, determined to be whichever one the outcome suggests. The trial of Parthenia. Sizemore, for the murder of Calvin Sizemore, opened on February 3rd, 1901, in the Breathitt County Courthouse. The courthouse was a brick building of no particular architectural distinction, 2 stories, with a courtroom on the upper floor that held perhaps 100 spectators under normal circumstances. On February 3rd, it held considerably more than that. Word had gotten around, the way word always gets around in small counties, that this was not going to be the simple proceeding that the prosecution had anticipated. The Courier-Journal correspondent, a man named Thomas Reed, 34 years old, 11 years into a career in journalism, who would later spend 3 decades trying to reconstruct what he witnessed in that room, had arrived the day before, and had already filed a preliminary dispatch describing the county and the circumstances. People had come in from the hollows, people who had lost land to Calvin Sizemore's machinations, people who had bought land from those machinations, people who were simply curious in the way that communities are curious about the trials of their own. The gallery was full, and the overflow stood on the stairs and in the corridor below. The judge was not a local man, which was the first surprise. A visiting circuit judge named Roscoe Kraft had been brought in from Breathitt County's judicial district, a man from Frankfort with a reputation for running tight courtrooms. He was 61 years old, had been on the bench for 22 years, had seen most of what courts could produce, and had the particular quality that distinguishes the best judges from the merely adequate ones: the ability to recognize quickly and without self-deception when something unusual is happening. Hayden Hargis opened for the prosecution with the precision and confidence of a man who had not yet been told that the case had changed. He laid out the facts as he understood them. The defendant had killed her husband, had admitted killing her husband, had been found at the scene of the killing. He anticipated a short trial, a conviction, and a sentencing proceeding that would probably result in a term of imprisonment. He was, in manner and approach, a man finishing a task before lunch. Virgil Stanton's opening was different. He stood before the jury, 12 men, farmers and tradesmen, and one schoolteacher, drawn from the county's population with whatever degree of impartiality was achievable in Breathitt County in 1901. And he told them, quietly and without theatrical emphasis, that this was not a case about whether Parthnia Sizemore had killed her husband. She had. She would not contest that fact. It was not in dispute. The question before them, Virgil said, was different. The question was, why? And more than why. The question was whether the why mattered, whether the context mattered, whether a court of law had any obligation to hear the evidence before it reached a verdict, or whether it was merely a machine for confirming what everyone had already decided before the first witness took the stand. He told them about the ledger. He described it briefly, what it was, how long it had been kept, what it contained. He told them that the defense would call witnesses who would corroborate its entries. He told them that by the time the defense had finished its case, the jury would understand not only why Parthnia Sizemore had done what she had done, but also, and here his voice shifted slightly, taking on a quality that Thomas Reed would later describe in his notes as a kind of sorrowful precision. They would understand why no other remedy had been available to her. Judge Kraft watched this opening with an expression that Reed described as unreadable but intent. Hayden Hargis objected twice, was overruled twice, and sat down at the prosecution table with the look of a man who has just realized that the terrain has changed beneath him. The prosecution's case was brief and factual. 2 witnesses. Deputy Tackett, who testified to finding Parthnia at the scene with the weapon and describing what she had said. A physician who had examined Calvin's body and testified to the cause of death. Hayden Hargis kept the examination of both witnesses tight and clinical, doing what he could to create a record of simple, undeniable facts before Virgil had the opportunity to complicate them. When he passed the witnesses to Virgil for cross-examination, Virgil's questions were equally brief. He was not interested in the prosecution's case. He was already looking past it. The defense began on the morning of the second day, and it was the second day that Thomas Reed would spend the rest of his life trying to adequately describe. Virgil's first witness was a woman named Eula Combs. She was 53 years old, a widow. She lived, she told the court, on a tract of land her husband had farmed for 30 years before his death, a piece of ground of about 80 acres on a creek that fed into the North Fork of the Kentucky River. She had 3 children still at home. She had a cow, a mule, a kitchen garden, and 30 acres in cultivation. She was describing the life of a subsistence farmer with the matter-of-fact precision of someone who knows exactly what she has because she has counted it carefully. In 1898, she told the court, she had received notice that her title to the land was being challenged. The challenge came through the office of Calvin Sizemore, acting in his capacity as a consultant on land matters for a group of investors. She used the word investors, the way people use words they've been taught to use, carefully and without full understanding of what it means. The challenge alleged that her husband's original title had been improperly registered, that a survey conducted in 1879 had contained an error, and that the land reverted, on proper legal examination, to an estate in which the investors had a claim. She had tried to contest this. She had gone to 2 lawyers in the county. The first had told her the case was too complicated for him to handle. The second had taken her money, and then, after 3 months, informed her that he was unable to continue representation. She had gone to the county clerk's office to examine the records and had been told that the relevant documents were not available for public inspection. She had written to the state authorities. She had received a form letter in return. She had lost the land. She was now a tenant on ground that she and her husband had broken, cleared, fenced, and farmed for 30 years. Hayden Hargis objected that the testimony was irrelevant to the question of the defendant's guilt. Judge Kraft overruled him. He would be overruled on relevance objections 17 more times over the course of the trial. Eula Combs stepped down, and Virgil called his second witness, a man named Alfred Creech, who had served as deputy clerk of courts for Breathitt County from 1891 to 1897. He was a thin man in his late 40s, with the kind of careful stillness that can indicate either calm or suppressed agitation, and which, in Alfred Creech's case, turned out to be the latter. Virgil's examination of Creech was methodical, unhurried, and devastating. He led the witness through his duties as deputy clerk, establishing his familiarity with court records and filing procedures. Then he asked Creech to describe his relationship with Calvin Sizemore during his tenure as clerk. Creech hesitated. The hesitation was visible to everyone in the courtroom, a pause that lasted perhaps 4 seconds, but which felt, in the silence of that packed room, much longer. Judge Kraft, who had been making notes, looked up. Creech said, "He gave me instructions on certain records." Virgil said, "What kind of instructions?" Another hesitation. Then, instructions about how they were to be filed. Sometimes about how they were to be written. "Are you saying," Virgil asked, with the careful cadence of a man who knows exactly where he is going, "that Calvin Sizemore, who was not a court official during much of your tenure, directed how official court documents were prepared?" Creech looked at his hands. "Yes." "And did you follow those instructions?" The silence before the answer was the longest yet. Thomas Reed, sitting in the press gallery, later wrote that during that silence he became aware of an extraordinary quality in the air of the courtroom. A collective held breath. The sensation of a community on the edge of some recognition that it had been postponing for a very long time. Creech said, "God help me. Yes." What followed was 40 minutes of direct examination in which Alfred Creech with the stumbling and sometimes incoherent courage of a man confessing something he has carried for years, described the mechanics of Calvin Sizemore's operation as it ran through the clerk's office. Records had been altered. Dates had been changed. In several cases, documents had been substituted. A replacement survey filed over an original, an amended deed quietly replacing the deed on record, a foreclosure notice predated to create the appearance that proper legal procedures had been followed when they had not. Creech had done these things because he had been instructed to do them, because Calvin had told him they were routine legal corrections, and because here his voice broke and he had to stop and collect himself, because he had needed the income that Calvin provided on top of his clerk's salary, and because he had been afraid. He named names. Not all the names. He did not name names above a certain level of power, and his hesitations around certain questions were eloquent about who those people were. But he named enough. He named the specific transactions he had participated in. He named the families who had been displaced as a result. He corroborated, in detail, specific entries in Parthnia's ledger, which Virgil had entered into evidence on the first day, and which now sat on the exhibit table beside the bench, its mottled cover facing the courtroom. When Hayden Hargis rose for cross-examination, he had the look of a prosecutor who has discovered, mid-trial, that the building he is standing in may be on fire. His cross-examination of Creech was brief, and, it must be said, not entirely ineffective. He established that Creech had personal reasons to misremember events from a decade ago, that his memory of specific details might be colored by the current proceedings, that his earlier silence on these matters raised questions about his credibility as a witness. It was competent work. It was also, in the context of what Creech had just said, insufficient. You do not rehabilitate a confession with a credibility attack. The damage was in the room, and the room knew it. Creech stepped down. He walked back through the gallery to a seat near the door. Reed noted that no one met his eyes, and that this seemed to pain him. The afternoon of the second day produced the county surveyor, a man named Jasper Holliday, who had held the elected position of county surveyor for 12 years, and who came to the stand with the look of a man who has calculated his options and found all of them bad. Virgil's examination of Holliday was more contentious than his examination of Creech. Holliday resisted, qualified, denied, retreated, qualified again. But the ledger was there, and Virgil had prepared with the ledger, and whenever Holliday denied something that the ledger specifically documented, Virgil would produce the relevant page, read the entry aloud with its date and parcel, description, and dollar amounts, and wait. Holliday's story, under this pressure, gradually changed. The falsified surveys did not become not falsified. That was not possible, because the physical documents existed and Virgil had copies of several. But they were, in Holliday's revised account, not exactly falsified in the sense of being fraudulent, so much as they were corrected, adjusted, updated to reflect more current measurements, and if certain measurements happened to move a boundary line in a direction that benefited a particular party, well, measurements are not perfect, and he had done his best with the instruments available. This recharacterization did not go over well in a courtroom that had spent the morning listening to Alfred Creech. It went over even less well when Virgil produced 2 survey plats side by side. The original survey from the county records, obtained with considerable difficulty from Frankfurt, and the amended survey that Holliday had filed in its place. and asked Holliday to explain why the original boundary stone at the northwest corner of the Combs tract had been moved in the amended survey a quarter mile to the east. Holliday said he must have made a mistake. Virgil said, "According to this entry in the ledger, you were paid $40 for that mistake on the 14th of March, 1898. Do you recall receiving that payment?" Holliday said he recalled no such payment. Virgil said he expected that might be the case, and moved on. The third day opened with the witness that, by Thomas Reed's later account, most visibly shook the courtroom. A man named Bertram Hale, who was the vice president of the Bank of Jackson and the county's most prominent financial institution. Hale was, by the standards of Breathitt County, a wealthy and respected man. He was on the board of the local church. He was a member of every civic organization of consequence. He had never, so far as anyone knew, been directly involved in any of the feud's violence or its more obvious legal corruptions. He was, in the taxonomy of small-town power, one of the respectable ones. His appearance at Virgil's table as a defense witness had been preceded by a subpoena, which was how Virgil had managed it. He had subpoenaed the bank's records, and he had subpoenaed Hale personally, and Hale had arrived at the courthouse with a lawyer of his own who had spent 2 days trying to quash the subpoena and had failed because Judge Kraft, whatever his other qualities, was not the kind of judge who quashes subpoenas once he has decided they are properly issued. Virgil's examination of Hale was the longest of the trial. It ran for most of the morning. It was also, in Reed's account, the most technically complex, involving the identification of specific bank accounts, the tracing of specific transactions, and the documentation of a pattern that would not have been visible to anyone who had not spent considerable time with both the ledger and the bank records that the subpoena had compelled. Calvin Sizemore, it emerged, had maintained accounts at the Bank of Jackson under 2 names that were not his own. One was a variation of his initials. One was the name of a deceased cousin whose estate Calvin had at some point administered. These accounts had received, over a period of approximately 10 years, a series of deposits that corresponded with remarkable precision to specific transactions documented in Parthnia's ledger. More significantly, the depositors, traced through the bank's records under Virgil's methodical questioning, included not 1, but 2 sets of clients who should, by the logic of the feuds, have been enemies. The Hargis faction had deposited money into Calvin Sizemore's accounts. The Callahan faction had deposited money into Calvin Sizemore's accounts. Not different accounts. In several cases, the same accounts. Calvin Sizemore had been receiving payment from both sides of the feud, sometimes in the same month, sometimes for transactions that directly opposed each other, because what he was selling was not loyalty to either faction, but the legal machinery that both factions needed to legitimize what they were doing. He was not an ally. He was a utility, and both factions had been paying his bills. The courtroom, which had been steadily filling over the 3 days of the trial, word had continued to spread. People had continued to arrive from farther and farther afield, and on the 3rd morning, Judge Kraft had had to have the sheriff manage the crowd on the stairs. Received this information with a quality of silence that Reed described in his notes as the silence of a room in which a great many people are simultaneously realizing something they should have realized a long time ago. Hayden Hargis, whose family's name had now been directly implicated in the payments to Calvin Sizemore, objected He objected strenuously. He objected in terms that grew progressively less precise and more heated. Judge Kraft overruled him each time, with increasing briskness, and at one point told the prosecutor, in a voice carefully calibrated to carry to the gallery without seeming to perform, that if counsel could not compose himself sufficiently to make specific and coherent objections, the court would note that counsel had no objection and proceed accordingly. Hale stepped down. He walked out of the courtroom and did not return for the remainder of the trial. Reed, watching him go, noted that several men in the gallery watched Hale with expressions that he found difficult to categorize. Not quite anger, not quite contempt. Something more complicated. The specific expression of people watching someone who had for years been able to pretend that his hands were clean discover that they are not. The afternoon of the third day was taken up with 3 additional witnesses: a timber company agent who had been served with a subpoena in Lexington and had traveled to Jackson under protest, a former justice of the peace who had presided over several of the forfeiture proceedings Calvin had engineered, and a woman who had been employed as Calvin's secretary for 6 years and who testified with a brevity and a quietness that was somehow more effective than any amount of elaboration would have been, that she had been instructed to keep no copies of certain categories of correspondence, and that she had, on 2 occasions she could specifically recall, watched Calvin Sizemore burn documents in his office fireplace. Each witness added a thread, each thread connected to others. The picture that was assembling itself in the courtroom was not the picture of a single corrupt man, but of something larger and less resistible. A system, a way of doing business that had been operating so long and involved so many people that it had ceased to look like corruption and had begun to look like order. This was how things worked. This was how land changed hands, how titles got cleared, how the legal framework adapted itself to the realities of power. Calvin Sizemore had not corrupted the system. He had been the system, or a crucial part of it, and the system had worked quite well for everyone who had access to it, and very badly for everyone who did not. Parthnia Sizemore had spent 16 years documenting this. On the 4th morning of the trial, she took the stand. She wore dark clothing, which was appropriate for a woman in her circumstances, but she wore it without the carefully performed grief that the conventions of the period would have suggested. She was composed. She was not cold. Thomas Reed would be at pains in his notes to distinguish between the composure she displayed and coldness, and to insist that the distinction was real and important. But she was precise, and the precision had the quality of something that had been prepared for a long time, something that had been organized and rehearsed, not in the theatrical sense, but in the sense of being genuinely understood before it was expressed. Virgil's direct examination of Parthenia ran for 4 hours. It was, by any account, extraordinary. He began at the beginning. Her marriage to Calvin, her early understanding of what his practice involved, the moment of realization that had led her to begin keeping the ledger. He asked her to describe the ledger itself, its physical form, its organization, the method by which she had gathered the information in it, the precautions she had taken to keep it hidden. He asked her to walk the court through specific entries, explaining each one: the name of the party whose land had been affected, the nature of the fraud, the date, the amount Calvin had received. She did this for 3.5 hours. Not all of it. The ledger contained far more entries than any trial could accommodate. But enough of it, and the enough was chosen with surgical precision. Virgil had selected entries that would be corroborated by the witnesses who had already testified. He had selected entries that named the families most significantly affected. He had selected entries that showed the pattern most clearly. The way Calvin had moved between factions, the way the amounts had increased over time, the way the scheme had expanded as it became clear that no one was going to stop it. Parthenia described each entry in the same voice, measured, precise, without editorial. She did not editorialize about Calvin's moral character. She did not describe her own suffering or her years of secret grief. She stated facts. She provided context. She answered Virgil's questions with the brevity and accuracy of a good witness and the comprehensiveness of someone who has been preparing for this particular testimony for 16 years without knowing exactly when it would be delivered. She described the Mullins transaction last. She explained what she had learned and when. She explained her understanding of what would happen to the Mullins family if the transaction proceeded. She explained that she had considered what alternatives were available to her, and she described that consideration without drama. The lawyers she could not approach, the officials who were participants, the governor's office that was not meaningfully accessible to a woman in Breathitt County in 1901, the federal authorities whose interest in land title fraud in eastern Kentucky was, at that time, theoretical. She described the absence of remedies, not as an excuse, but as a fact, established and documented the same way every other fact in her testimony was established and documented. Then Virgil asked her, "And what did you decide?" She said, "I decided that if the law could not stop him, then it was my obligation to stop him in whatever way was available to me. I decided that whatever I had to pay for that decision was worth paying." The courtroom was very quiet. Virgil said, "Did you understand, when you made that decision, that you might be put to death for it?" Parthenia said, "I understood that I might. I made the decision anyway." The cross-examination of Parthenia Sizemore by Hayden Hargis lasted 40 minutes, and it did not go well for the prosecution. Hargis was in an impossible position. The most effective approach to cross-examining Parthenia would have been to attack the ledger, its reliability, its completeness, the accuracy of its entries, the possibility that Parthenia had misunderstood or misrecorded what she had witnessed. But attacking the ledger meant attacking it in specific terms, which meant identifying specific entries and arguing that they were wrong, which meant putting the specific entries before the jury again and drawing additional attention to them. Every line of attack that was available to Hargis ran directly toward the explosive material he was trying to prevent from detonating. He tried anyway, because he had no choice. He attacked Parthenia's credibility as a witness. Was she not, he suggested, a woman with an obvious interest in the outcome of this proceeding? She agreed that she was, and noted that all witnesses had interests of some kind, and asked whether the interests of the witnesses who had testified for the prosecution should also be examined with equal rigor, which Judge Kraft sustained as a legitimate observation, and Hargis could not effectively counter. He attacked the ledger's foundation. How had she gathered this information, and could she be sure she had gathered it accurately? She described, in methodical detail, the process by which she had corroborated each entry, the overheard conversations, the documents she had been able to examine, the witnesses who had corroborated specific entries during the current proceedings. He attacked her character. What kind of wife kept secret records of her husband's business? She said the kind of wife who lived with a man who used the courts to steal from his neighbors, and who believed that someone should be keeping records of it. He tried, finally, to isolate the killing as an act of passion rather than calculation, to suggest that whatever the ledger contained, whatever the broader context, what had happened in the study on that January morning was a moment of violence between a husband and a wife that had nothing to do with ledgers or land titles or the corruption of county government. She looked at him for a moment, and Reed noted that her expression in that moment was the only time during her entire testimony that something close to emotion was fully visible, though even then it was difficult to name exactly what the emotion was. She said, "Mr. Hargis, I am sitting in this courtroom in front of a jury with my life at stake, and the only thing I am sorry about is that it took me so long." Hayden Hargis had no further questions. Virgil's closing argument was short. This surprised the gallery, which had been expecting, based on the preceding days, another extended performance. But Virgil had understood something important about this jury and this case. The case had already been made. Every additional word was risk. What he said in 11 minutes was essentially this: that the jury had heard the evidence, that the evidence was corroborated and documented, that the defendant had told the truth in this courtroom when everyone else in this county had been telling lies for 20 years, and that whatever they thought about the act she had committed, they had an obligation to consider the context in which it had been committed, and what the verdict they returned would say about whether this county and its courts were capable of hearing the truth when it was told. He sat down. Hayden Hargis gave a closing argument that lasted 35 minutes, and that Thomas Reed described in his notes as technically proficient and emotionally vacant, the argument of a man who knows he has lost and is executing the formal requirements of defeat. It covered the law. It covered the facts as the prosecution had presented them. It asked the jury to consider the social order that would result if wives were permitted to decide when husbands deserved to die. It was not, Reed noted, the argument that Hargis would have given if he had been fully committed to the outcome, and the jury could probably feel the difference. Judge Kraft charged the jury at 4 p.m. They retired to deliberate. They came back 11 minutes later. 11 minutes is, by any standard, an extraordinarily short deliberation for a murder case. It does not allow for extended discussion. It barely allows for a formal vote. What 11 minutes says, in the body language of a jury, is that the members had already decided, or that the first person to speak in the room articulated what everyone in the room had already concluded. Either way, the foreman, the schoolteacher, a man named Markham, stood up and said the word that Thomas Reed would underline 3 times in his notes. Not guilty. The courtroom erupted. Not in celebration exactly. The nature of what had just happened was too complicated for simple celebration. There was noise and movement and a quality that Reed struggled to describe accurately and eventually settled on. The sound of a community that has just had something confirmed about itself that it was not entirely sure it wanted confirmed. Some people were crying. Some people were silent with an intensity that looked like shock. One woman in the gallery stood up and began to applaud, and several others joined her, and then others did not. And the sound was irregular and strange. Not the clean applause of a theatrical audience, but the broken sound of people who are not quite sure what they are applauding. Parthnia Sizemore sat at the defense table and received the verdict with the same composure she had maintained throughout the trial. She did not cry. She did not embrace Virgil, who was standing beside her. She nodded once, with the air of someone receiving a report they had expected, and then she turned and looked at the courtroom, at the people filling the gallery, at the officials at their tables, at the journalist in the press box. With an expression that Reed could not describe, and would spend the rest of his life trying to. That was 4:47 in the afternoon of February 14th, 1901. By the following morning, the machinery of erasure was already in motion. It began that night, while most of the courthouse audience was still processing what they had witnessed. The first thing that happened, according to the account that the Louisville Courier-Journal correspondent would eventually piece together years later, was a meeting. Not a formal meeting. There was no scheduled gathering, no announced assembly. But in the way of small communities where power knows how to find itself, the people who needed to talk to each other found a way to talk. What united them, across factional lines that had been killing people for years, was a single and clarifying shared interest. The ledger, and what it had revealed, could not be allowed to stand as a public record. This was, in its way, a remarkable moment. The Hargis faction and the Callahan faction had been shooting at each other for years. They had ordered murders and conducted ambushes and stood in open-armed opposition to each other throughout the previous decade. They had nothing in common except that both of them had, in specific transactions documented in a dead man's wife's account book, paid for the same legal services. Both of them were in the ledger. Both of them had been implicated in the testimony. Both of them understood, with the clarity that shared vulnerability tends to produce, that the existence of the official trial record, the transcript, the exhibits, the entered evidence, the docket entries, was an ongoing threat to both of them. The question was how to make it stop existing. What happened over the next 48 hours was, in the language of later investigators, a conspiracy of convenience. No one needed to organize it explicitly because everyone understood what needed to happen. The specific mechanics were left to the people best positioned to execute them. Virgil Stanton was found on the morning after the verdict at the edge of the road between the courthouse and his lodgings. He had been beaten with sufficient thoroughness to fracture 2 ribs and produce a concussion significant enough that he would later report being unable to remember the beating itself or the hours that preceded it. His briefcase, which had contained his copies of the trial documents and his notes from the proceedings, was missing. The ledger, which had been in his possession as the exhibit copy, was also missing. When he recovered enough to speak coherently, he told the sheriff's deputy who was assigned to take his statement that he had no useful information about who had attacked him and no information about where the ledger had gone. His tone, in the deputy's account, was the tone of a man who knew more than he was saying and had made a decision about how much of it to say. He left Breathitt County 3 days later. He returned to Lexington. His subsequent career in law was conducted entirely in commercial matters. He never took another criminal case. he maintained, in the correspondence that survives from the later years of his life, a consistent silence about the Sizemore trial. He mentioned it in a single letter, written in 1931, 30 years after the fact, to his former law professor. "I think about Breathitt County sometimes, and I believe that what we did mattered, even though what happened afterward made it seem like it hadn't. The truth was in the room. I don't know what you do with that, but I know it was there." The court records had been removed from the courthouse files within 24 hours of the verdict. Judge Kraft, who had departed for Frankfurt on the morning after the acquittal, later reported to the state court administrator that on the day of his departure, the records had been present and properly filed. He had no knowledge of who had taken them or by what authority. He had, he noted, conducted the trial according to law and had no comment on subsequent events. The state court administrator's records indicate that a request for the trial record was received from the governor's office shortly after Kraft's report, and that the request was accompanied by a directive from the governor sealing the proceedings. There is, as previously noted, no corresponding executive order in the governor's files. What there is in several letters from the period are references to extended conversations between the governor's secretary and representatives of two prominent eastern Kentucky families. The family names are not given, but the description of them as families with significant political interests in Breathitt County leaves the identification essentially unambiguous. The docket book was altered at some point during this same period. The pages for February 1901 were cut from the binding and removed. Someone was careful enough with the cutting to leave the stubs intact, perhaps because the spine would have been visibly damaged without them, perhaps because whoever did the cutting was more careful about appearances than about completeness. The cut marks are still there. Parthnia Sizemore was released from custody following the verdict. She had been in the county jail for approximately 3 weeks. On her release, she collected the small amount of property that had been permitted to her in the jail, and, as best the surviving records indicate, walked out of the Breathitt County Courthouse and did not come back. She had no family in the county who could take her in. Her husband's family, predictably, had no warmth for her, and her own family was scattered. She'd been acquitted of murder, but she had also, in the process of her acquittal, made a documented record of who in Breathitt County had done what to whom, and she had remained in Breathitt County long enough to understand what that meant for her future there. She disappears from the records entirely for a period of about 3 years. There is no trace of her in the Breathitt County records, which is not surprising. There is no trace of her in adjacent counties. She had not used a train ticket under her own name at the nearest station, or at least no record of such a ticket survives. She simply was not there, and then she was not there, and the gap extended. She appears again in Cincinnati in 1904, listed in a city directory as a bookkeeper employed by a dry goods importing firm. She is listed under the name P. Collins, her maiden name, and her address is a boarding house in the neighborhood of Over the Rhine, the large German-American working-class district on the north side of the city. She is, by the time of this directory entry, 37 years old. She is working. She is living quietly. She is apparently not in contact with anyone in Breathitt County, and no one in Breathitt County appears to be looking for her. She continued to work as a bookkeeper in Cincinnati for the rest of her working life. She was well regarded by her employers. The dry goods firm was followed by an insurance company, then a small manufacturing concern. She never married again. She became, in time, a member of the Methodist Church in her neighborhood and appears in its records as a reliable attendee and occasional contributor to its charitable activities. When she retired, she had saved enough money to maintain herself in her boarding house for the rest of her life. And when she died in 1934, at the age of 67, her obituary in the Cincinnati Enquirer was 4 sentences long and described her as a retired bookkeeper with no surviving immediate family. The obituary did not mention Breathitt County. It did not mention Calvin Sizemore. It did not mention a trial in February 1901 whose records had been cut from the binding of a docket book and whose mention had been erased from the governor's files. Parthnia Sizemore had lived her second life in Cincinnati with the thoroughness and consistency of a woman who had understood, from the beginning, that the ledger she had kept for 16 years was the only record of hers that was going to survive, and that even that had not survived in the end. The Courier-Journal correspondent, Thomas Reed, returned to Louisville after the trial and filed his dispatches. They were published, and they caused a brief sensation. The story of the verdict, the story of the ledger's contents, the story of the trial's remarkable 5-day structure received the attention that remarkable stories receive. There were follow-up articles. There were editorials. There were official statements from the county and the state that were carefully worded in ways that acknowledged the trial had occurred without acknowledging anything it had revealed. And then, as tends to happen with remarkable stories that occur in places that the mainstream of power finds convenient to ignore, it faded. Other stories replaced it. The Eastern Kentucky feuds were always generating new material. The specific revelations of the Sizemore trial were absorbed into the general reputation of bloody Breathitt as a place where terrible things happened and where the law was not, in any practical sense, operational, and the absorption made those revelations less specific and therefore less useful. Reed kept his notes. He kept them for 30 years. He retired from the Courier-Journal in 1931, having spent a career writing about the state of Kentucky, with the particular combination of admiration and exasperation that career journalists develop for the places they cover. He kept working on the Sizemore story in his retirement, not obsessively, his family later said, not in the way of someone consumed by a single thing, but consistently, the way you work on something you know is not finished. He wrote several attempts at a longer account that were never published. He conducted additional interviews with people who had been present at the trial when he could find them. He found several of the jurors, elderly men in the 1930s, who were willing to talk in general terms about what they had witnessed, but not willing to be quoted by name on specifics. He tried, repeatedly and unsuccessfully, to locate the ledger, which had vanished as completely as Parthenia herself. When he died in 1941, his family found a shoebox in his study containing his original notes from the trial, his interview transcripts, and his unpublished drafts. The shoebox sat in his daughter's attic for 37 years. In 1978, a graduate student at the University of Kentucky researching the Breathitt County feuds found Reed's daughter's name in an old Courier-Journal staff directory and wrote her a letter on the off chance that she might have family papers that were relevant. The daughter, then 73 years old, remembered the shoebox. The graduate student drove to Louisville and spent a day with its contents. The graduate student's name was Margaret Holden. She wrote her dissertation on the Hargis-Callahan-Cockrell feud, and the Sizemore trial occupies a chapter of it, the most careful and fully documented account of the trial that exists. She published several articles based on her research. She tried to find additional primary sources and found almost none. The official record had been too thoroughly removed. What she had was Reed's notes, and what Reed's notes contained was the account of a journalist who had been present for 5 days of extraordinary proceedings, and who had understood, from at least the second day, that what he was witnessing was something that someone would try to prevent from being remembered. He had written down everything he could. It wasn't everything. It was never going to be everything. But it was enough to know that the thing had happened, enough to know the shape of it, the participants, the evidence that had been presented, the verdict, the aftermath, enough to understand what the gap in the docket book represents and why it is the shape it is. The gap has a specific shape. It begins after January 28th and ends before March 3rd. It is precisely the shape of 5 weeks of proceedings, a trial that lasted 5 days, followed by the days of frantic destruction, followed by the time it took for the governor's office to formalize what had already effectively happened. The shape of the gap is the shape of a trial in which a woman testified for 4 hours about the systematic corruption of a county's legal system, was acquitted in 11 minutes, and was then subjected to an erasure so complete that for most of the century that followed, no one knew to look for what was missing, because they did not know anything had been there. The Mullins family, for what it is worth, kept their land. Whether this was a direct result of the trial's proceedings or whether the collapse of Calvin Sizemore's operation simply removed the mechanism by which the title challenge was to have been prosecuted is not entirely clear. The timber company eventually acquired adjacent lands through other means, but the Mullins tract itself passed intact through subsequent generations. There are Mullins family members living on parts of it today, though most of the ridge was sold in the 1960s during the broader timber and mineral rights transactions that transformed land ownership throughout eastern Kentucky. There are other fragments. A church bulletin from a Cincinnati Methodist congregation, dated December 1929, contains in its regular members' notes a brief entry about a P. Collins who had contributed to the Christmas collection fund, and who was, the bulletin noted with the small pride that church bulletins take in member accomplishments, a particularly meticulous keeper of accounts. Someone who had read Margaret Holden's dissertation found this bulletin in the 1990s and sent her a photocopy with a note suggesting it might be the same woman. Holden agreed that it probably was. She published the possibility in a short article. The article generated a modest amount of correspondence from people in Breathitt County whose families had been mentioned in Reed's notes and who had various reactions: gratitude, defensiveness, curiosity, to seeing the story in print. In 2001, a small group of local historians in Breathitt County, working with some of that correspondence and with Holden's research, had a marker placed at the courthouse in Jackson. It was a simple thing, a bronze plaque on a post, the kind that historical commissions place to mark events. It said, in full, in memory of Parthnia Sizemore, who told the truth when no one wanted to hear it. February 1901. The marker was removed within a week. No explanation was given, and no authority claimed responsibility for the removal. The post hole was filled, and the ground was smoothed over, and the courthouse lawn looked as it had before, empty of the particular kind of acknowledgement that the marker had represented. The local historians made inquiries. They were told, by various officials and semi-officials, various versions of the same basic message. There was no documentation to support the claim that the events described on the marker had occurred, and erecting memorials to undocumented events on courthouse grounds was not appropriate. The fact that the documentation was missing because someone had removed it, the fact that the absence of documentation was itself a piece of the history being commemorated, was noted by the historians, but did not apparently move the relevant decision-makers. The post hole has since been replanted. There is a municipal flower bed there now, zinnias in the summer, bare in the winter. It is, in its way, a kind of monument, not to Parthnia Sizemore specifically, but to the general capacity of institutional power to smooth over its own tracks with patient and unremarkable persistence. But the gap in the docket book is still there. If you go to the courthouse and you ask the clerk, and she sets the volume on the counter in front of you, and you run your finger along the gutter where the pages were cut, you can feel the stubs. They are still there, after more than 120 years. Little paper tongues, a quarter-inch wide, the raw edges oxidized to the color of old leather. Someone counted them. There are enough stubs for 40 pages. 40 pages of double-sided entries in the careful copperplate of a county clerk trained to produce complete records, documenting 5 weeks of proceedings that someone decided should not exist. The stubs are not documentation, in the way that a transcript is documentation. They are not evidence in the way that a ledger is evidence. They are a form of negative proof, the shape of an absence that tells you something happened here, and that the happening was significant enough to make powerful people afraid of it, and that when powerful people are afraid of something, they have, in almost every era and almost every context, the capacity to make it not exist in the official record while being entirely unable to make it not exist in the world. Parthnia Sizemore kept a ledger for 16 years in the base of a sewing basket. She kept it because she believed that the truth, carefully recorded, would eventually matter. That there would come a day when the system would be capable of receiving it. She was wrong about the day, as it turned out. The system that received her truth was not prepared to preserve it, but the impulse that had driven the keeping, the belief that documentation is a form of resistance, that writing things down is a way of refusing to let them disappear entirely, turned out to be more durable than she perhaps knew. Thomas Reed wrote down what he saw. Margaret Holden found the shoebox. The graduate student wrote the dissertation. The local historians placed the marker. Each of these acts is a kind of rekeeping, a recollection of what the official record chose to forget. They are imperfect, incomplete, dependent on fragments and inference, and the reports of observers who were not trying to write history so much as trying to understand what they were looking at. But here is what we know. In February of 1901, in a packed courthouse in Jackson, Kentucky, in the most violent county in America, a 34-year-old woman took the stand and testified for 4 hours about what she had documented in 16 years of meticulous record keeping. She named names and gave amounts and cited dates and did not cry and did not ask for sympathy and did not present herself as anything other than what she was, a person who had known what was happening, had written it down, and had eventually decided that writing it down was not enough. A jury of 12 men from Breathitt County, men who knew the families she was naming, men who lived in the system she was describing, men who had every reason to hear none of it, listened to everything she said, went into a room, and came back 11 minutes later with 2 words: not guilty. It took them 11 minutes to decide that the truth she had told in that room to that court mattered enough to act on. 11 minutes to reach the verdict that every official mechanism subsequently worked to erase. 11 minutes against 120 years. The stubs are still in the binding. The gap is still in the record. And history, as it turns out, has a way of bleeding through the cuts.